Good afternoon. Welcome everybody to the Fair Housing Center of Southwest Michigan's Full Use, Full Enjoyment, Reasonable Changes for Fair Housing training. This training will focus on disability. And before we get into the nuts and bolts, we're going to do a little bit of housekeeping here. First and foremost, we'd like to thank the Michigan State Housing Development Authority, or MSHDA, without whose grant we wouldn't be able to offer this training free of charge. Secondly, the Fair Housing Center of Southwest Michigan is not staffed by attorneys, and so the information in this presentation is presented for educational purposes only and does not constitute legal advice. So, a little bit about us here at the center. The Fair Housing Center of Southwest Michigan, we promote integration and work to eliminate housing discrimination through education, advocacy, and enforcement of the fair housing law. By promoting integration, we mean that in pursuing our mission, we aim to reverse the segregatory effects of societal decisions. And when we say eliminating discrimination, we mean that we aim to remedy the actions of individuals. Now, we use three tools for this. That's education, advocacy, and enforcement. And we are intentional about that ordering. So the Office of Housing and Urban Development, or HUD, estimates that annually there are 4 million occurrences of housing discrimination nationwide. However, only about 11,000 of these are reported. So the logic goes, if we educate well enough, then ideally we can eliminate housing discrimination before it begins. However, education can also encourage people to recognize and report potential housing discrimination they're dealing with. And at that point, we can advocate on their behalf or work to secure justice through enforcement of that fair housing. So, what is fair housing? In brief, fair housing is the right to equitable access to housing and housing services at all levels or during all aspects of the housing transaction. Fair housing can also be considered to be an effort to empower individuals to be free to make their own choices regarding their housing. Under certain conditions, impediments to that free choice can constitute illegal discrimination, which fair housing then seeks to eliminate. One thing we like to say in fair housing is where you live affects how you live. So offering free choice of where offers free choice of how. So fair housing seeks to eliminate housing discrimination. And there is a formula for determining whether a situation constitutes housing discrimination, and it consists of three elements. The first thing that has to be true is that the dwelling in which it occurs is a covered dwelling. And this is very nearly all residential constructions. Almost all residential constructions are covered by the Fair Housing Act. It should be assumed then that if a person lives there, the dwelling is covered. There are, of course, some limited exceptions that we'll get to here in a moment. But the second part of the formula is a protected person. So federally, there are 7 protected classes. Those are race, color, religion, national origin, sexual orientation and gender identity, family status, and disability status. Now, state and local governments can add to, but they can never remove these protections. And each of these protections were won over time. They have associated laws and case law, and we'll cover that in a bit more depth very soon. And finally, the practice needs to be unlawful. So that means that the practice, or excuse me, an unlawful practice is any practice that treats differently any member of a protected class during any part of the housing transaction, whether that different treatment is intentional or just has a different effect. And we'll go through that again here in just a moment. So to get into covered dwellings, a dwelling under fair housing is to be construed as broadly as possible. So like I said, there are very limited exceptions, but alongside those, all places of residence that are not strictly commercial ventures, something like a hotel or a motel, are covered by the Fair Housing. Also, all aspects of the housing transaction are covered, like we mentioned. So not only does the Fair Housing Act prohibit kicking a person out of their rented apartment based on, say, their national origin, but it would protect that same person from similar discrimination during the application process for that apartment. In the process of securing a loan from a bank in order to buy a home, or after having purchased that home, fair housing still applies to an appraisal process, say. Now, where covered dwellings are concerned, we have an interesting edge case in mixed-use dwellings such as Airbnbs or long-term hotel stays. And how the fair housing law applies is largely based on the presence of a primary residence. So in the case of hotels, for instance, fair housing seldom applies, as a guest in a hotel usually has a primary residence elsewhere. In the case of something like a shelter stay for an unhoused person, though, the stay could be short, rather, or shorter than a hotel stay, but fair housing will apply because no other primary residence exists. So again, broad construal covered dwellings cover houses, apartments, transitional housing, shelters, college dorms, even the site of housing construction is covered under the Fair Housing Act. So what then are the exempt dwellings? There are three classes of dwelling where the fair housing laws are exempted. So the first would be that in limited circumstances, the Fair Housing Act will make allowances for housing operated by religious organizations. So religious organizations are allowed to give preference to people of the same religion if the housing is non-commercial. Excuse me, if the housing is non-commercial and the religion itself doesn't discriminate based on other protected classes. So for example, a Catholic organization owns some homes and they can legally limit occupancy or otherwise give preference to other Catholics so long as those leased homes aren't being commercially operated. The next case of exempt dwelling is covered by what's known as the Mrs. Murphy Rule. This protects small holding housing owners from fair housing laws. So federally, what that means is a residence that comprises 4 or fewer units and that is presently occupied by the owner of that property or members of the owner's immediate family. That property would be exempt from fair housing law under this. Each state has its particular version of the Mrs. Murphy Rule, and here in Michigan, it's the same as the federal rule, except that it restricts the residence to 2 or fewer units. So it's a bit more restrictive. And finally, and appropriately for today, we have housing designated for older persons. These are things covered by the Housing for Older Persons Act, or HOPA. And housing meant for older persons is exempt federally from only familial status protections and is separated into 2 categories. We have housing for people 55 and older and housing for people 62 and older. These are split, and because of that split, a number of rules apply to these types of housing. So in housing meant for people 55 and older, 80% of those units need to be occupied by at least one person, at least 55 years old or older, and the terms, regulations, and advertisements pertinent to that dwelling must clearly state their intent to operate as housing for people 55 or older. In housing for people 62 years and older, those same rules apply, except 100% of the units must be occupied by at least one resident of the target age. However, usually disabled people can live in either class of senior designated housing, regardless of their age. And in both cases, there are further exemptions that will allow caretakers, employees, property managers to live in, say it's an apartment building, to live there regardless of their own age. And then even with these exemption cases, it's never permissible to discriminate in the advertisement of any part of a housing transaction. So those are the covered dwellings and the exempted classes of dwellings. So let's move into protected classes or protected persons. Federally, There are 7 protected classes, which you'll see presented here in red. No state can limit these protections, but states can add to them. And for their smaller local municipalities, can add even more. Here in Michigan, the additional protected classes that apply most to housing are age and marital status. You'll notice other there is presented in gray alongside the other 2 Michigan laws. That is because the controlling Michigan civil rights laws list more than just age and marital status as protected classes, but these extra protections apply usually to cases of employment instead of housing. So although weight is a protected class under Michigan disability laws and civil rights law, weight discrimination is seldom an issue in fair housing cases. So for our purposes, marital status and age are the fair housing protected classes in Michigan. Here, I'd like to make a brief note on language. So throughout this training, I'll be using both class and characteristic sometimes to refer to the protected classes. Protected class is the language that's within the fair housing law, but sometimes it makes less sense or is a little more awkward to describe someone as being in the class of families with children, for instance. So again, for our purposes, both protected class and protected characteristic refer to these protected classes. So what do we mean when we talk about the protected class of race? That means that you can't discriminate on someone, against someone based on their race, and that includes all races. Color refers to the color of someone's skin. So for instance, a darker skinned person of Indian descent has the same rights as a person of Indian descent with lighter skin. Religion includes one's membership or lack thereof in an organized religious group. It also covers one's spiritual ideas or beliefs. National origin is about where a country, is about the country where a person was born or from where one's ancestors came. Sexual orientation and gender identity pertains to one's actual or perceived sexual orientation, as well as the identity, expression, or perception thereof. That includes one's relevant attitudes, preferences, beliefs, or practices of their gender, irrespective of its relation to their sex assigned at birth. Family status is the presence of one or more children under 18 in the household, as long as they're in a custodial relationship with an adult. So that's a parent, a step parent, an adoptive parent, a guardian, a foster parent, otherwise the custodian of a minor child, a pregnant person, or someone who is in the process of acquiring legal custody of a child. Disability then would be our last federally protected class, and that is the focus of today's training. We'll discuss it in detail shortly. So in Michigan then, marital status protects people who are single, married, separated, engaged, widowed, divorced, and in some jurisdictions simply cohabitating from discrimination in fair housing, or rather in housing. And age it relates to individuals of any age. So each of these classes, as we mentioned, are protected by specific laws that were won and passed over time. We're going to turn now to a timeline of these laws. The League of Fair Housing statutes, the timeline is by no means comprehensive, but it's a good snapshot, we think, of those moments where protected classes with respect to housing were enshrined into law. So if we start in the top left with the Civil Rights Act of 1866, that's shortly after the end of the Civil War. Amendments 13 and 14 were ratified, and newly freed slaves and native-born Black Americans were finally recognized as citizens. So again, the Civil Rights Act of 1866 details primarily the economic and property rights of these new citizens, including explicit protections against abridging those rights on the basis of race or color. Of course, one act would not go on to eliminate all race or color-based injustice in the United States. And the next 100 years, we'd see various laws passed, we'd see Supreme Court decisions that all worked toward the same project of securing the civil rights of the nation's newest citizens. So one of these big moments of political activism comes again in the Civil Rights Act of 1968. So a lot of strides were made, but despite those strides, activists in the civil rights movement of the mid 20th century uh, were still fighting against race-based housing patterns here in the United States. So, for instance, while Black and Hispanic members of the U.S. military were fighting and dying in Vietnam, their families here at home often struggle to rent or purchase housing in residential areas because of their race, color, religion, or national origin. So, following pressure from organizations such as the NAACP or the GI Forum, um, alongside the pressure generated by the assassination of Martin Luther King Jr., the pressure generated by those subsequent riots in more than 100 US cities, uh, President Lyndon Baines Johnson was able to whip the votes to push and accomplish the passage of the Civil Rights Act of 1968, Title 8 of which is now known as the Fair Housing Act. So this act establishes race, color, national origin, and religion as protected classes in housing transactions. Then we have a handful of amendments to the Fair Housing Act. The first amendment would be in 1974 to add sex as a protected class, and then again in 1988 to add family and disability status as protected classes. Executive Order 13988 is not shown on this timeline, but that was in 2021 and elaborates on the protected class of sex to explicitly include all sexual orientations and gender identities as a protected class. So that brings me to the second note on language. Previously, the laws have pointed to sex and gender, LGBT, LGBTQIA+, etc. protections. But because of the language of this latest executive order, I use sexual orientation and gender identity as a general term to include varied peoples who comprise this protected class. Here in Michigan, alongside the federal fair housing laws, we've passed the Elliott Larson Civil Rights Act here in Michigan. That added marital status and age protections in 1975. And then later in 2023, the Elliott Larson Civil Rights Act, or ELCRA, was amended in 2023 to mirror the language of that executive order to add protections for all sexual orientations and gender identities. So we've gone over dwellings, we've gone over protected classes. What are the unlawful practices? So they come in four flavors generally. There's discriminatory intent, there's disparate impact, there's retaliation, and there's failure to accommodate. So only behavior that involves one or more of the protected classes is legal under the Fair Housing Act. So for example, a landlord who refuses to rent an apartment to a prospective tenant has not, in that simple act, violated the Fair Housing Act. So even though a covered practice and a covered property may be involved, unless it can be also shown that the landlord's action was based on race, color, religion, sexual orientation or gender identity, disability, family status, or national origin. If the landlord's action was based on any other factor, so for instance, the prospect had bad credit, no violation of the act has occurred. However, the landlord doesn't need to have been acting maliciously or otherwise with discriminatory intent. The practice is prohibited even if it has a disparate impact. And that is to say that a practice can appear neutral, but because of how the protected classes intersect with reality, it could have a disparate impact. So for instance, consider the following hypothetical. A property developer wants to build affordable housing specifically intended for occupation by nurses, say. A career is not a protected class, so nominally that would seem above board, maybe even a good thing to do given the profession. But then if you take a step back and look at the developer's area, 95% of all nurses are white. So by attempting to limit access to the dwelling only to the area's nurses, the developer has unintentionally limited access based on race, and that creates a disparate impact. Retaliation describes when a housing provider does something like raises the rent, withholds maintenance, or harasses a tenant after they assert their fair housing rights. And retaliation comes into play even when a complaint in itself wouldn't constitute illegal housing discrimination. Retaliating against that tenant for raising that complaint, however, is a violation of the Fair Housing Act. And finally, and most importantly to today, failure to accommodate is a housing provider's failure to allow reasonable accommodations or modifications. These are things that would better allow a disabled person to exercise their right to full use and enjoyment of their dwelling. This is one of the most common practices cited in fair housing complaints and takes us into the focus of our session today. So again, just a brief reminder, the Fair Housing Center of Southwest Michigan, we're not attorneys. The information in this presentation does not constitute legal advice. It's presented for educational purposes. So disability and fair housing. According to the National Fair Housing Alliance's 2024 Fair Housing Trends Report, disability accounts for a majority, or 52.6%, of all fair housing complaints. It's the most cited protected class. As a protected class, people with disabilities are unique in at least one respect amongst the protected classes, because they're the only minority that can be discriminated against solely by the design of the built environment. And we'll examine that through a discussion of the laws underpinning disability discrimination protections and a discussion on reasonable accommodations and reasonable modifications. So before we do any of that, however, we need to take a look at what we mean when we say disability under the law. So as with many aspects, a disability under the law is defined as a physical or mental impairment that substantially limits one or more major life activities. So like many aspects of fair housing, a major life activity and consequently disability should be construed broadly. And you can see some of the major life activities, they're often cited. It's worth noting, of course, that this is not an exhaustive list at all. A person with a disability further does not necessarily need to be disabled for these laws to apply. That is to say that a person protected with regards to their disability under law is someone who does actively live with an impairment that substantially limits one or more major life activity, someone who is perceived as having such an impairment, someone who has a history of having had such an impairment, or someone who associates with a so defined disabled person. So these extensions are important because, as we'll see, the housing rights of disabled persons were lockstep or may have slightly lagged the protections afforded in employment cases or their legal labor rights. So from there, we learned that many major life activity limiting impairments are not in fact disabling, but are believed to be so. And the people who have them may be denied employment or be otherwise shunned as a consequence. And such people, objectively capable of performing just as well as the unimpaired, are analogous in that way to capable workers discriminated against because of, say, their skin color or some other vocationally irrelevant characteristic. It makes sense then to extend from employment law this same logic to housing. And finally, it's worth noting here that not all disabilities are visible. A person may visibly require the use of a wheelchair, but legally they're no more or less entitled to disability protections than a person who lives with a less visible, let's say, stress disorder. So there are 4 key laws that underpin, the disability protections afforded in fair housing. The first of those will be the Rehabilitation Act, Section 504 of the Rehabilitation Act. That was passed in 1973 and is a federal law. The next in the timeline is the People with Disabilities Civil Rights Act, or PDCRA, here in Michigan. That was passed in 1976. Then we have the Fair Housing Amendments Act, or FHAA, of 1988. We mentioned that earlier. And finally, the Americans with Disabilities Act, or ADA, of 1990. So we're going to briefly go through each of these laws in turn. Section 504 of the Rehabilitation Act was the first civil rights legislation designed to protect disabled people from discrimination. Section 504 of the RHA prohibits discrimination on the basis of disability exclusively at this point in programs receiving federal financial assistance, as well as those conducted by federal agencies. Things that are in the areas of, say, healthcare, public education, transportation, subsidized housing. Of course, again, not an exhaustive list. But it did, for example, cover all health and human services programs and activities funded by the HHS or the Department of Health and Human Services. That includes hospitals, doctors' offices that accept Medicaid or Medicare, states' child welfare programs. And Section 504 protects people with all types of disabilities and disabled people of all ages. That includes older adults who would need assistance with major life activities like walking, getting in and out of bed, hearing or seeing, who may not even think of themselves as people with disabilities. Next, then, we have essentially the Michigan version of the Rehabilitation Act. The People with Disabilities Civil Rights Act removes the qualification that a program covered by the act be receiving state funding or state operation or management. It also provides that qualified individuals with a disability must be provided with reasonable accommodations, that as long as those accommodations do not impose undue hardship on the program that is making the accommodation. And what constitutes an undue hardship, we'll get into momentarily. We have the Fair Housing Amendments Act of 1988. And this is the last major amendment to the Fair Housing Act itself. It also delineates the laws on accessible construction. And in it is stated that all covered multifamily dwellings that are to be constructed for first occupancy on or after March 13th, 1991 must be accessible constructions. Now, of course, not every disabled person lives in multifamily housing. Not all family housing in which disabled people live was constructed after 1991. And for those reasons, housing needs to be available to be made accessible through, again, those reasonable accommodations or modifications, which I promise we'll get to in just a moment. So the Fair Housing Amendments Act of 1988 continued. I mentioned that it dictates that all covered multifamily housing needs to be in accessible construction. There are 7 key rules to that. So to be considered an accessible construction, a dwelling needs to have an accessible entrance on an accessible route. It needs to have accessible and usable common and public use areas. The doors need to be sufficiently wide to accommodate wheelchair travel. The accessible routes need to run into and through each dwelling. And an accessible route is something without obstacles, something with those wide doorways. Light switches, electrical outlets, thermostats, other environmental controls all need to be in accessible locations, generally a little bit lower. And reinforcements to bathroom walls to allow later installation of grab bars. And finally, usable kitchens and bathrooms, such that an individual using a wheelchair can maneuver about and use the space. And so these rules, although developed for the Fair Housing Act or the Fair Housing Amendments Act, these design rules also apply to multifamily dwellings covered by Section 504 and the ADA, with one significant exception. Properties or parts of properties that are deemed, quote, public accommodations covered by the ADA must also furnish van accessible parking spaces. And the rules on this are, there always needs to be at least one accessible van space, and then one ADA compliant parking space per 1 to 25 other parking spaces. So from spaces 1 to 25, you can have one ADA compliant space, 26 to 52, one of which needs to be van accessible, et cetera, et cetera. So if a place is subject to the Americans with Disabilities Act, which most public accommodations are, the design and construction must meet then the 7 Fair Housing Act design rules, plus the accessible parking rules of the ADA. And this is the Americans with Disabilities Act, or the ADA. It's rooted in Section 504. Some important changes are it changes the legal language to refer to disabled and not, quote, handicapped persons. It more broadly defines disability, noting that a condition need not be severe or permanent to constitute a disability. It also limits the definition such that it cannot any longer include certain specific conditions that were previously widely considered to be antisocial or otherwise transgressive and would uh, inhibit those major life activities. But these are things like kleptomania, and this limit was to avoid abuse of the statute's purposes. The ADA of 1990 also notably removes someone's sexual orientation as being able to be classified as a disorder, and that excludes it from the definition of disability. Now, the important ones for fair housing are Titles 2 and 3. Title 2 applies to housing operated by state or local governments. Title 3 applies to public utilities and commercial entities, such as realty offices, loan agencies, other places where different aspects of the housing transaction may occur. The ADA also further defines a number of standards for accessible constructions. These are things such as the specific heights of raised braille signage in public spaces, the width of parking spaces, and a lot more. However, now that we've covered the 4 controlling laws for disability, I'd like to move the focus now to disability and housing. So a key phrase when we're talking about disability and housing is full use and enjoyment, or the right to full use and enjoyment. While a person with a disability is protected under fair housing law from all forms of discrimination that may occur in a housing transaction, something like a refusal to sell or rent to a person because of their disability, different terms on a loan because of someone's disability, restricted access to amenities in an apartment complex, charging more because of a person's disability. The most common form of discrimination toward people living with a disability is a failure to accommodate. And that is a failure on the part of a housing provider or otherwise controlling entity to allow for changes to rules or spaces to afford that person their right to full use and full enjoyment of the property we're dwelling. So we're going to start by discussing reasonable accommodations. Then we'll move into reasonable modifications. Then we'll talk about undue burden, or what constitutes reasonability. And then we will move into the very limited exemption case of what's known as direct threat, where disability protections do not apply. So a reasonable accommodation, much like a dwelling, it's a broad concept. What's needed and how it's provided depends on the circumstances. Crucially, it is incumbent upon the person with a disability to request an accommodation. Generally, they do know their needs best. The idea always is to assist the tenant in achieving full use and enjoyment, but not by placing an undue burden on the housing provider. So these are changes to rules, policies, procedures, services provisions, well, I'm sorry. To continue, let's think again about the distinction between visible and invisible disabilities. So it's unfortunate, but it is often true that invisible disabilities can be treated with more suspicion by housing providers. the need for a wheelchair is easier to see for a housing provider or easier to prove to an outside observer than the need for an animal that might help you manage your post-traumatic stress disorder. Uh, Reasonable accommodations then are needed when a person with a disability asks for them. The reasonable accommodation helps them achieve full use and enjoyment, and the reasonable accommodation does not constitute an undue burden. There's no standard catalog of accommodation. People have unique needs, of course. And so, again, for that reason, it's the responsibility of a housing provider to listen to reasonable accommodation requests in good faith, to not assume what a person may or may not need, and to continue working alongside that person, what's called an interactive process, if one accommodation might not work, but the problem still needs to be solved. So there, to better illustrate, here are some common examples of reasonable accommodations. So it may be appropriate to permit a tenant with a mobility impairment to mail in their rental payment as opposed to paying it in person. In cases where a rental agreement doesn't allow overnight guests, it can be reasonable to permit tenants with disabilities to have a 24-hour personal care assistant who stays with them in their apartment. Now, in most, but not all places, this caregiver is not beholden to rent requirements. They're not a tenant, they're a worker. It'd be like charging a maintenance person rent for the time they spend in the unit. Sometimes the number of ADA required accessible parking spots may be insufficient for every tenant who could benefit from them. Way around this is to reserve a parking spot that would otherwise be first come, first serve. This is usually one that will lessen the distance or lessen the number of obstacles, make more clear the path between the spot and the person's dwelling. Some people with disabilities may have little or no rental history. Maybe they previously lived with relatives or in an otherwise non-traditional rental setting. It can then be appropriate as an accommodation for a housing provider to accept a reference from an employer or a social worker, caseworker, family member in lieu of rental history. And finally, and this is a pretty big one, is that even if there's a no pets policy, a disabled tenant must be allowed to keep a service or companion animal if they can provide proof of that. So we're going to talk about those support animals here. We're going to start that with a note on language. So variously, I will refer to the animals that help a person with the symptoms of their disability as service, support, or companion animals. Emotional support animals, or ESAs, is another common one. But because a person's disability does not exist only within the home, it's useful to maintain those distinctions while remembering that fair housing laws do not distinguish them. And what I mean by that is that the Americans with Disabilities Act does maintain a separate definition for service as opposed to support or companion animals. Under the ADA, a service animal such as a seeing eye or leading dog for the visually impaired, a service animal is protected, its presence is protected in public spaces, whereas a support or companion animal under the ADA generally is not. The Fair Housing Act applies to one's own home, though, and so the distinction is less relevant. It should be remembered, though, that the care that can be provided by an emotional support animal is no less important than that provided by a service animal. So a service dog can act as a leader for the visually impaired. Different service dog may be trained to act as a stability aid, be trained to open doors or fetch medicine. Some of them can even smell oncoming seizures. Of course, the list is by no means exhaustive, and those are all important functions, of course, but an emotional support animal often serves a less visible but no less important function. These are things such as reducing stress during an anxiety attack, distracting from or halting self-destructive behaviors, comforting during PTSD episodes, of course, as usual, not an exhaustive list. So one of the most common accommodations that does arise in fair housing is these service, support, or companion animals. So when a tenant indicates a need for a service animal, The housing provider can, especially in the case of an invisible disability, request that the tenant provide a letter from a healthcare provider verifying that the tenant does have a disability and that the animal does alleviate a symptom of that disability. Now, a history of case law has found that licensing or certification of service animals is not required, so long as the tenant can demonstrate that the animal provides necessary assistance. And a note on this, some internet services will offer ESA certifications for a fee, but because licensing or certification are not required, licensing and certification are not sufficient. If a service sells certifications without any input uh, or interaction with a healthcare professional, it shouldn't be relied upon. Of course, the waters get muddier again then because we now have online healthcare services that may legitimately be able to provide the appropriate information. Um, but what's important there is that there's a history of care with the requester. Now, uh, just to reiterate, a housing provider can't inquire specifically about the disability the person has or the services that the animal provides. And while many support animals are dogs, a support animal can be any type of animal. It's been borne out time and time again in fair housing cases nationwide. They also don't need to wear any special harness or tag. They don't need to have, again, any special certification or licensing. In some cases, an individual with a disability may require more than one support animal. All that's required is that there be a nexus of care between the animal and the disability. That is, the animal provides some function that alleviates the symptoms of the disability. Uh, the proof that someone requesting the accommodation must then present is a healthcare professional's acknowledgement of that nexus of care. So put differently, these following slides contain the letter of the law. So I'm going to read them verbatim. So this is from a HUD guidance on an executive order. So housing providers are to evaluate a request for a reasonable accommodation to possess an assistance animal in a dwelling using the general principles applicable to all reasonable accommodation requests. After receiving such a request, the housing provider must consider the following. 1, does the person seeking to use and live with the animal have a disability? That is, a physical or mental impairment that substantially limits one or more major life activities. 2, does the person making the request have a disability-related need for an assistance animal? In other words, does the animal work, provide assistance, perform tasks or services for the benefit of a person with a disability, or provide emotional support that alleviates one or more of the identified symptoms or effects of a person's existing disability? Where the answers to questions 1 and 2 are yes. The Fair Housing Act and Section 504 require the housing provider to modify or provide an exception to a quote, no pets rule or policy to permit a person with a disability to live with and use an assistance animal or animals in all areas of the premises where persons are normally allowed to go. If the answer to question 1 or 2 is no, then the Fair Housing Act, Section 504, do not require a modification to a provider's no pets policy, and the reasonable accommodation request may be denied. So again, what needs to be true is the presence of a disability and work that the animal does that alleviates the symptoms of that disability. So we've gone on about this for a little while, but emotional support animals do continue to constitute the basis for a large proportion of fair housing complaints based on disability. But because mental or emotional impairments are not usually visible, they're therefore subject to biases of perception, and the role of ESAs can be poorly understood. It might seem that a tenant just wants to keep a pet, which ESAs are not pets. It may seem that they want to just keep a pet and are using an ESA claim to skirt a no pets rule. It's important to remember that these companions can help in all sorts of ways that are also not readily apparent. This includes being a calming presence in a stressful situation, encouraging hygiene and exercise. We mentioned preventing or interrupting impulsive or damaging behaviors. Some of them alert people with diabetes when their blood sugar is low through smell. They can remind a person to leave the isolation of their home or to interact with others, and alleviating symptoms of depression that can lead to worse symptoms. And just for a little levity, perhaps support animals can come in all shapes, sizes, and species. Wally the alligator is an emotional support animal for a man in Pennsylvania. So before denying a reasonable accommodation request due to a lack of information concerning an individual's disability or the nexus of treatment, a housing provider is expected to engage in a good faith dialogue with the requester, called by HUD the interactive process. A housing provider, again, may not insist on specific types of evidence if the information otherwise provided meets the requirements laid out in this training. It's never necessary for a requester to disclose the specific diagnosis or severity of their disability, nor their medical records or exams. So we'll move now from reasonable accommodation to reasonable modifications. So where support animals are a reasonable accommodation in that the housing provider accommodates the tenant by waiving their no pets policy to allow the presence of the animal or the animals in the home. Sometimes, though, what's needed is not an accommodation, but a modification. So where a reasonable accommodation is an adjustment to rules or procedures, a reasonable modification is an alteration to the physical space that, it can assist the tenant in navigating the space, such as a grab bar on a slippery surface, such as in the shower, or ramps to allow wheeled travel. It may assist a tenant in being alerted to changing information in their home, something like lights flashing instead of a doorbell going off for a hearing impaired person. Now, of course, this is a short and inexhaustive list of reasonable modifications. And you can't really make an exhaustive one because it's up to the person who has the impairment to determine what modifications suit their needs. But again, yeah, like a widened doorway, zero-step showers instead of a high bathtub wall, reinforcements to a wall such that they can install a grab bar. These are all other examples of modifications. So it's usually inexpensive or free to adjust rules and regulations for reasonable accommodation. But if you're going to build a ramp, for instance, that requires time, it requires labor, it requires materials, all of those things cost money. So who pays? Generally, a tenant is expected to cover the expenses of making reasonable modifications unless those modifications also benefit the whole building. This is true in private housing. So for instance, if you're changing the rules to allow a reserved parking spot, that rule change costs nothing, but printing and installing the sign that designates the spot as reserved will have a cost, and the tenant will usually be required to cover those costs. This is not the case in subsidized housing, such as Section 8 or Rural 515 programs, where the housing provider would be generally required to cover those costs. The owner of a modified dwelling may also always require that the unit be returned to its original conditions, unless the modification is moved. So for instance, a housing provider might require that the grab bars in the shower be removed at the end of the disabled person's tenancy. They're well within their rights to do so. If, however, the wall behind the shower needed to be reinforced such that a grab bar could support the weight it needed to support, that reinforcement does not need to be removed. It's a neutral change. And what that means is it does not impede the next tenant's right to full use and enjoyment of the dwelling. So again, similarly, things like widened doorways or wheel ramps in common areas, these are almost always neutral modifications. And finally, in order to reduce the associated costs, someone requesting a modification may sometimes offer to install the modification themselves. The housing provider always has the right to ensure that the modification is carried out professionally or in a workmanlike fashion. So, what constitutes reasonability? As long as the accommodation or modification doesn't account for what's known as an undue burden, this is usually financial or administrative, usually considered reasonable. And I said a nexus between a few times. That's a term from HUD for the characteristic of an intervention that helps to ease the strains on regular life activity caused by a disability. So, for example, a seeing eye dog's ability to lead a person is the nexus between the disability, the visual impairment, and the accommodation, waiver of no pets policy. The guaranteed shorter or safer travel distance from a reserved parking spot to the residence is the nexus between the disability, motor impairment, and accommodation, waiver of open parking policy. And I've noticed we're running a little long, so please do bear with me as I move a little more quickly. So, of course, then there are situations where the accommodation or modification is not reasonable. An example from HUD. So let's say we have a tenant, Marge, who suffers from chemical sensitivity disorder. And she requests that the owner survey all tenants in the building to determine the time in the day and the chemicals they will use to clean their units. She's asked that the owner compile this information for her on a weekly basis so that she can plan to be away from her unit at the time when certain chemicals are used. It's pretty obvious where the administrative burden would be there. However, it wouldn't be an undue financial or administrative burden for the owner to notify Marge in advance before cleaning common areas, or to ask the cleaning crews to use less pungent non-chemical alternative cleaning methods. We also have here that, a request can also be considered unreasonable if it constitutes a fundamental alteration. That would be when the accommodation requested would cause the housing provider to change the way they do business, or where what's requested goes beyond what is normally provided. So an unreasonable modification then could be requesting the installation of a motorized chairlift where a ramp would otherwise suffice. In all cases, though, where an accommodation or modification is deemed by the housing provider to be unreasonable, it's their duty to work with the tenant to try to find a more reasonable solution. So, reasonable accommodations or modifications can be requested at any time. Residents with non-visible disabilities may be asked to provide documentation on why the accommodation is needed. You can request more than one accommodation or modification at once. Reasonableness is not defined under law. It's a case-by-case basis, which often means that it's decided at litigation. And more information can be found in HUD statements or memos from the Office of Fair Housing and Equal Opportunity, or FHEO. So an example of a reasonable accommodation case comes from our friend Daniel Black of Lansing. He's requested a walk-in shower to alleviate the difficulties of stepping into the tub. He also requested that the building install an accessible electric entrance door. The apartment was federally subsidized, which means that it probably should have already had an accessible electric entrance door and accessible showers. However, the case went on for quite some time. Eventually, I believe this was back in 2023, the case was dismissed after an undisclosed settlement and the installation of those modifications. So we mentioned that, like everything, there is an exemption in limited cases, and this exemption is known as direct threat. In limited cases, a person's disability may increase the possibility that the individual poses a threat to the safety of their neighbors or presents a risk of damage to the property. It's a rare case and must always be examined on a case-by-case basis. However, in these times, the disability protections of the Fair Housing Act do not apply. The continued presence of a threatening person abridges the fair housing rights of that person's neighbors. Again, they have an equal right to full use and enjoyment. Of course, there are best practices. You can't exclude individuals based upon fear, speculation, or stereotype about a particular disability or persons with disabilities in general. An assessment you generally want to include rather nature, duration, and severity of the risk, probability of injury occurring, and whether there are accommodations that could eliminate that direct threat. There have been cases where direct threat claims have been upheld even when there's no actual evidence of harm to other tenants. One case, Foster v. Tinney in 1997, for example, a particular tenant was above and beyond belligerent and threatening, made inappropriate sexual remarks. So, in this case, no physical harm had been realized, but it was reasonably suggested that the tenant did constitute a threat. Again, this just underscores that it's important to consider the facts on a case-by-case basis. There are just a couple more limited exceptions where disability protections do not apply. So current illegal drug use, recall that a person who's had a history of having had a disability is protected by disability laws. Disability protections are afforded to addicts as long as that addicted person is in recovery. Current and ongoing drug addiction, and alongside it, the manufacture or distribution of controlled substances attendant to that addiction are not viewed as a disability. Sex offenders whose actions require a lifetime registry. This, at one point, people would argue that it could be considered a disability, but it is not covered, regardless of whether their offenses stem from DSM-related disorders. So we've covered the exemptions. How can we enforce, and what are the remedies for transgressing disability protections like Daniel Black's housing providers did in the earlier case? So generally, justice and fair housing takes two shapes: administrative complaints or private rights of action. So you can make an administrative complaint to the Department of Housing and Urban Development, Department of Justice, a fair housing assistance program agency, which is something like the Michigan Department of Civil Rights, or private fair housing agencies like the Fair Housing Center of Southwest Michigan, what are known as, which are agencies funded by the Fair Housing Initiatives program. Private right of action means civil, or in extreme cases, criminal litigation. And the remedies that can be won from either of these are, again, not an exhaustive list, but something like injunctive relief. So a court-ordered cessation of discriminatory practices. You could be awarded the housing that you were previously denied in a discrimination case. If it goes to litigation, compensatory or civil penalties may be awarded, so compensatory damages. These would be the remuneration of money spent on pursuing remedy, money that can be shown to have been lost because of the discriminatory practices. Civil penalties would be a court-defined fee that would be assessed to disincentivize future discriminatory practice. Punitive damages, so like a civil penalty, but much stricter or much more severe. Set-asides, which would be a presently unavailable but reserved remedy to the practice, so something like an apartment or a parking space. The discriminatory party may be subject to monitoring or training under their fair housing responsibilities. And again, not an exhaustive list at all, but there are statutes of limitation that control these processes. In federal cases, administrative complaints have a statute of limitations of 365 days. Here in Michigan, the statute is 180 days from date of last discrimination. So if, for instance, you've made 3 reasonable accommodation requests, the clock starts on the day of denial of the third. And then private right of action, 2 years federally to bring a civil case and 3 years in the state. So apologies for flying through a little bit there at the end, but we do have a couple of resource slides. Direct Threat, the National Housing Law Project is a good resource. ADA.gov has a lot of information on the Rehabilitation Act, the ADA, the People with Disabilities Civil Rights Act can be found online at the State of Michigan Legislative Council. And then Undue Burdens, HUD Exhibit 2.6 or 2-6, excuse me, has a lot of good examples of what might be considered undue financial or administrative burden. We've got the Department of Housing and Urban Development. And these are, this last page of resources is about fair housing more generally. So with that, I would like to thank you for attending and to open the floor for questions.